Hello, everyone. We're going to get started with the breakout in this room. If everybody could please sit down. All right, our next speaker is Rebecca Hobbs, and Rebecca is a certified elder law attorney from O'Donnell, Weiss, and Mattei law firm, and she is going to talk about medical trusts and estate planning for special needs.
Hi, good afternoon. So a little bit about me, and then we'll delve into the topic. So first, thank you for having me today. So my name is Rebecca Hobbs. I'm an attorney, and I practice primarily in the area of elder law, special needs planning, estates and trusts, and then I do veterans benefits planning as well. So I am licensed in Pennsylvania and New Jersey. And as we go through the topics, I'm going to kind of point out where you need to be mindful that there are very state-specific laws. So depending on where you reside, what state you reside in, you need to be mindful of the fact that I'm trying to keep the presentation general, but there are a lot of specific topics that are state-related. So I'll point those out as we go. So today, my agenda, what I'm hoping to cover, is kind of a really broad overview of special needs planning. So I'm going to talk about healthcare directives and living wills, and they may be called something different in your state, depending if you're from Pennsylvania or somewhere else. We're going to discuss power of attorney documents. Then we'll talk about guardianships, and again, that might be termed different in your state. Then special needs trusts, and then able accounts at the end. If we run out of time, I know the PowerPoint, I believe, will be available for you, and I'll linger after if you have questions as well. Okay, so first, planning in the event of incapacity. So anytime we're talking about estate planning, one of the key things to remember is estate planning should be done regardless of medical condition, regardless of family situation for anyone, in my opinion, over the age of 18. So two key documents for everyone are an advanced medical directive and a durable financial power of attorney. And we're going to delve into those specific documents. So first, what is a healthcare power of attorney? So this document is really important because it allows an individual, allows an agent that you appoint to make healthcare decisions for you if you're no longer able to do that for yourself. So this document does not take away your rights to make decisions for yourself. It only enables somebody else to speak on your behalf. So there's no stripping of autonomy, there's no stripping of independence. It really is just appointing an agent of your choice to make decisions for you if you're unable to make and communicate decisions on your own behalf. So in Pennsylvania, and again, this document, so a healthcare power of attorney document, a healthcare directive, and then we'll talk about a living will. Each state is going to have different requirements for what the document must contain. Each state is going to have different requirements for the signing of the document. But generally, a healthcare power of attorney document is what we call springing. So what that means is that your agent that you appoint in your document has no authority to act on your behalf unless you're not able to act on your own behalf. So a doctor would need to indicate that you're not able to make or communicate your own decisions. And then at that point, your agent, their powers spring into effect and they can make decisions on your behalf. So again, springing, which means it springs into effect when you're not able to make those decisions on your own behalf. And so that's a healthcare power of attorney. A living will is different. So the healthcare power of attorney is effective anytime you're not able to make or communicate your own decisions. But a living will has even more requirements as to when that's going to be effective. The idea of a living will which is also interchangeably referred to as an advance directive. This document is going to provide your wishes, your instructions regarding end-of-life care. So this document is going to be operative. One, you have to provide the copy of the document to your physician or to the doctor, because they're not going to know you've signed such a document unless it's presented. So generally, a family member, when this document is being taken into effect, generally a family member or a friend will provide that document to the physician and say, you know, this person did execute an advance directive or a living will, here's a copy of it. A lot of times doctors will keep these documents on file, so they'll be aware that you've signed an advance directive and they'll have it on file already. But it becomes operative, of course, when it's provided and when two things happen. So one, you do have to be diagnosed with an end-stage medical condition and unable to make or communicate your own decisions. So if only one of those factors apply, the document won't be effective. So both of those things have to apply. So if you're diagnosed with an end-stage medical condition, but you're still fully able to communicate with the doctors and express your wishes, they're going to listen to you, not your document. It's only when you're not able to do that on your own behalf that the document will step in and speak for you as to what you would want to have happen in that situation. So in Pennsylvania, the healthcare directive and the living will are two documents that are kind of combined into one and then referred to as the advance directive. So again, the healthcare power of attorney portion, effective anytime you're not able to make or communicate your own decisions, and then the living will effective when you have those two things that apply. One, you can't make or communicate your decisions, and you've been diagnosed with an end-stage medical condition. So one of the most common questions I get from clients when they're going through an advance directive or signing it is, how is the living will different than a DNR order? So a lot of clients get hesitant to sign a living will because they think that by signing the living will, they're signing something saying they would not want to be resuscitated, and that's not correct. So a DNR order is something very different. That is something that's actually written by your doctor, and a medical order that's signed by your physician. And then that in Pennsylvania, again, this is state specific, but in Pennsylvania, you would identify yourself as being DNR by wearing a bracelet or a necklace, and then your chart would have that designation as well. There's also a new document that's, again, state specific. Not every state has adopted it, but it's called a PULSE form, and that is the PA orders for life-sustaining treatment. This document is intended to work along with an advance directive and along with a DNR, not meant to replace it. And this document provides specific orders regarding your current treatment, and it guides emergency personnel as well, where the living will won't guide emergency personnel. That document is meant kind of after the emergency subsides. So that is the healthcare directive, healthcare power of attorney, and the living will. Which, again, in my opinion, anyone over the age of 18 should have that document. It's really important to have. The second power of attorney document is a financial power of attorney or general power of attorney. Those words are kind of used interchangeably. But the idea of a power of attorney is, again, not the stripping of anyone's rights to make decisions for themselves. It is the empowering of someone else to make decisions on your behalf if you're not able to, specifically related to assets. So this allows you to appoint an agent to make decisions for you regarding your money, paying your bills, handling, signing various contracts on your behalf. The document can be really tailored to what your individual wishes are regarding the treatment of financial decisions. The financial power of attorney is different than the healthcare directive in that the financial power of attorney generally, again, state by state, but generally this document is effective immediately upon signing it. So one of the other common questions I get from people is, well, how do I choose who to be my agent under these documents? For some, it might be an easy decision, whether it's a spouse or a child that you trust, that you want to make decisions on your behalf. For others, it might be a more difficult decision if you don't have family nearby, if you're not married, if you don't have children. But it's important to look at the characteristics of the individual and decide, not only is this person willing to act on your behalf, but do they have the characteristics that are necessary to make good decisions for me? And just in my practice, these are some of the things that I have found are important. The lives closely factor, that I have found is important for healthcare decision making, not necessarily the financial decision making. Nowadays with online accounts and online bill paying and all of that, it's easy to do that long distance. But the healthcare decision making, a lot of times that requires you to be present for the different meetings with the physicians, to be present to sign documents, to be present to take him or her to the doctor. So that I have found is an important factor. Another question is, can I revoke a power of attorney? And yes, you can revoke it. So one of the important things to know is when we're talking about healthcare directives and when we're talking about financial power of attorney documents, those documents are effective only during your life. Upon you passing, the documents cease. But you can revoke them at any point. So in Pennsylvania, to revoke the document, you just have to sign something saying that you're revoking it. Okay, so now let's kind of shift gears. So when we're talking about healthcare directives and we're talking about financial power of attorney documents, those documents require legal capacity to sign the documents. So one, you have to be over the age of 18. Two, you have to be able to make and communicate decisions and express who you would want to be your agent. So in a situation where there's an adult, so an individual over the age of 18 that does not have the capacity, the legal capacity necessary to sign a document, such as a financial power of attorney or a healthcare power of attorney, then we're faced with the decision of filing for a guardianship. So first, what is a guardianship? So I do a lot of guardianship work in this area, Montgomery County and Chester County and Bucks County. And guardianships really, in my opinion, should be a last resort for an individual because a guardianship proceeding involves the stripping of the individual's rights to make decisions for themselves. So they are adjudicated an incapacitated person in the court of law. It does require in Pennsylvania a formal hearing before a judge. Testimony is presented, medical testimony is presented, and an order is then entered, assuming everything is successful, that adjudicates the person incapacitated and states that they can no longer make decisions for themselves. So then it's up to the guardian to make decisions for them. So there are two different types of guardianships in Pennsylvania, and again, different for each state. But in Pennsylvania, there is a guardian of the estate and a guardian of the person. Most states have something similar to that, whether it's called a conservator or a different title. Generally, you see guardianship or conservatorship are the two terms you see. And then the guardian of the estate is, so when we talked about the financial power of attorney, the guardian of the estate is just that person. It's the person making financial decisions for the individual. The person in charge of the money, person in charge of paying the bills, all of those things. That's the guardian of the estate. The guardian of the person is the individual in charge of deciding all the medical decisions, where the person will live, the care the individual will receive. That is the guardian of the person. So the disadvantages of a guardianship are it can be an expensive process, especially where there's a lot of litigation involved, where the family is not getting along as to who should be the decision maker for the individual. It can be very contentious, can be very expensive. It can be time consuming, and it does involve a very, in my opinion, invasive process because we are going to court, there's live testimony being presented. It is a closed courtroom, so only those that are allowed to be there, at least in Pennsylvania, can be there. But it does involve a profound loss of freedom and dignity. So again, guardianships are necessary in certain situations, but if you can avoid the guardianship, that's the best route. So guardianship should be the last thing that you look to. So you should look to every other alternative first. And if there are no other alternatives, and this really is the least restrictive alternative, then the guardianship is appropriate. So that is a very brief overview of power of attorney and guardianship. Then I wanted to kind of shift gears, and I'll try to get through this material and at the end save time for some questions. I wanted to talk about estate planning, which involves a little bit of talking about a last will and testament, and then we'll delve into the special needs trusts and how those coordinate with a last will and testament. And then we'll talk about able accounts as well. So a last will and testament, a lot of people are familiar with what that document is. So that document, of course, effective when you pass away, and that document directs who you want to receive your inheritance upon your death. So how do you want your assets to pass? A common misconception with a will is that many people think that a will controls everything that you own when you pass away, and that is not true. So different assets pass different ways. So a lot of people will have life insurance or IRAs or other retirement accounts. Life insurance, retirement accounts, generally will have a beneficiary designation. The beneficiary designation overrides what's in the will. So if your will says everything goes to my spouse or everything goes to my children, but then your beneficiary designation says everything goes to the next door neighbor, your beneficiary designation will control those assets that have the beneficiary designation. So those assets pass by contract. So life insurance generally, retirement accounts, sometimes investment accounts will have a transfer on death provision or a beneficiary designation. So those will be controlled by those designations as well. So why is this also important to know? It's important to know because when we start talking about special needs trusts, it will be important to know that those assets, if you want them to pass into a trust, you'll need to designate the beneficiary as such. So the last will and testament controls what we call your probate assets, which are the assets that are in your sole name. So if you have real estate but it's jointly titled, then that will not pass by your will. That will pass to the surviving joint owner. If you have a checking account that has a joint owner on it, passes to the joint owner. So the will controls, again, assets that are in your sole name, and they're called probate assets. Or sometimes as well, people will name on, I've seen this a lot recently, on life insurance, they'll name their estate as the beneficiary. If that is what you do, then it will pass through your will. Okay, so that is last will and testament. So now I want to spend a good amount of time talking about special needs trusts and why you may want to consider a special needs trust and then the different types of trusts. So very generally, why you would want to consider a special needs trust as part of your planning is that if the beneficiary that you want to bestow a benefit upon or you want to provide assets to is on any kind of public benefit, if they receive an inheritance directly, most likely, depending on the benefits that they're on, they will be kicked off those benefits. That is why a special needs trust is so important. So generally, when we're talking about special needs planning, the two primary benefits that that beneficiary may be on is SSI, which does have both an income and asset limitation, a very strict income and asset limitation, as well as Medicaid, not Medicare. So those two things are confused commonly. So when we're talking about special needs trusts, the two things that we're most commonly drafting for is SSI and Medicaid. And usually Medicaid is the biggest thing we're trying to protect. So SSI provides an income stream, but Medicaid is what is paying for a lot of those services that the individual needs, services and medical care. What's important to know is sometimes when I'm meeting with a family and we're talking about whether a special needs trust is appropriate, The first thing to do is to consider what public benefits that individual is on. Just because somebody has a disability does not mean they need a special needs trust. So it really is a case-by-case situation where you need to look at it to evaluate whether the special needs trust is necessary. Another really important thing to look at is with a special needs trust, there is this ability to asset management. So you're appointing a trustee that's kind of overview managing the money in the trust. So if you have a beneficiary that is not good with asset management, or maybe that's just something that they don't want to be involved with, that does provide a big benefit for the beneficiary, is the overview, the asset management that the trustee will provide. I did want to mention, so I talked just a second about Medicare and Medicaid being different. So with Medicare, that is an entitlement benefit. So with Medicare, there is no income or asset limits with Medicare. So that benefit, if a beneficiary is only on Social Security disability, not SSI, and Medicare, then they may not need a special needs trust. Sometimes you will have a beneficiary who is on Social Security disability, Medicare, and Medicaid. And in that situation, we would need a special needs trust. So it all depends on what that individual is, what benefits they're relying on, or what benefits they may need to rely on, as to whether a special needs trust is necessary. So when we talk about special needs trusts, generally there are three different types of trusts that we're referring to. So one is a first-party special needs trust, which we're going to talk about. The second is a third-party supplemental needs trust or special needs trust. Those terms are used interchangeably depending on the attorney. And then the third is pooled trusts, which pooled trusts can be both third-party and first-party. Okay, so first let's talk about first-party special needs trusts. So a first-party special needs trust really is exactly what the name is. So it's a trust that's established by the individual or by someone else for the individual, but it's funded with that beneficiary's own money. So this trust is most commonly used where you have an individual beneficiary who is on SSI or on Medicaid, and they come into an inheritance. So they've been on these benefits for a while, they've relied on them, there's something they need on a day-to-day basis, they're very important to them, and then a well-intended family member or friend leaves that individual money, not realizing that that money will then kick them off benefits. So in that situation, there is a way to do a first-party special needs trust, and we'll talk about the requirements for that. But that would be one situation that we're looking at doing a first-party special needs trust. Another situation is oftentimes if the disability is a result of an accident and there's a big personal injury settlement that we're dealing with, the first-party special needs trust will be used in that situation. But inheritance, so kind of unexpectedly coming into money, or where you have a beneficiary who has worked, has collected money throughout their life, and then they become disabled and need benefits, then we may be looking at a first-party special needs trust for them as well. But the main, if you think about it, first-party trusts funded with the own individual's funds. So what are the requirements for the establishment of a first-party special needs trust? So there are several requirements. So one of the main requirements to establish a first-party special needs trust is that the beneficiary must be under the age of 65. So that's one of the big requirements. Then there is a disability requirement. So you must be disabled per the Social Security definition of disability. And the first-party special needs trust must be established for one primary beneficiary, so for the sole benefit of an individual beneficiary. So this trust, again, is used in very specific situations. You would never want to use this trust as the way to plan to provide for an individual with special needs. So this is kind of this person came into money, what do we do to protect their benefits? One of the options is a first party special needs trust. So why isn't it something that you would just use? And that is for the biggest point on this PowerPoint, which is called a payback provision. So what that means is, yes, you can maintain your Medicaid benefits. Yes, you can maintain your SSI benefits and still have this money that you've put into a first party trust. But the state is going to keep track of everything they're paying out for your care. And upon death, then the state will come after the remaining balance in that first party trust. It's called a payback provision. So, for example, in Pennsylvania, the Department of Human Services, a state recovery unit, has a very specific department devoted to special needs trusts. And anytime a beneficiary of a special needs trust passes away, they then will come after the remaining balance of that trust, to the extent that they have paid out for your care. So if there's more money in there than they've actually expended on your care, they can't collect above that. But they do have this provision whereby they will claw back and attach to the money remaining in the special needs trust, which is why when we talk about the other options available, if you are planning for leaving an inheritance to an individual that's on public benefits, you would not want to rely on using a first party special needs trust for that very reason, is that payback provision. The qualified creator, I think I mentioned this in the beginning as to who can create the trust. So there was a big breakthrough in the special needs planning world where now the individual that needs the trust can create their own first party trust. Before, they were not an eligible person to create the trust. It had to be created by a parent or grandparent or legal guardian or the court. And that was changed through the Fairness Act, which I thought was a great thing to do and long overdue. So now the individual that needs the first party trust can create their own trust without needing a parent or guardian to sign off on it. Okay, so that is first party special needs trust. One thing that I failed to mention before we start talking about third party trusts is with a first party special needs trust, it's important to know that there are a lot of hoops and hurdles that you go through to create that trust. So, for example, in Pennsylvania, you do have to seek approval from General Counsel for the Department of Human Services. They have to review your trust and approve it. And the same thing with Social Security Administration for SSI, is they do review your trust and approve it. So there are certain steps that need to be taken when you're creating a first party trust. And it's not something, in my opinion, you should try to venture and do on your own. You really need an attorney that's familiar with all of these complex rules to guide you through that process. I unfortunately have met with people that have tried to do it on their own, or have not gotten the best advice and were trying to undo what had happened. And it's a mess. So if it's done right from the beginning, it's much easier to administer and much easier to continue with than if it was not done properly. Okay, so now talking about third-party trusts, which also can be referred to as supplemental needs. So I call my third-party trust supplemental needs, but it's just my way of identifying that it's a third-party trust opposed to a first-party trust. They really are both special needs trusts. So a third-party trust, very creative in its name, in that it really is just created with the funds of a third party. So the beneficiary themselves cannot put money into this trust. If the beneficiary needs to fund a trust, that's that first-party trust. So this is where you have someone who wants to leave money to an individual. So whether it is a grandparent or a parent or another family member, and they want to make sure that that individual is provided for and they want to provide an inheritance to them. The best way to do that, if that individual is on public benefits, is through a third-party supplemental needs trust. This trust is created by someone other than the beneficiary. So it really can be created by anyone. It doesn't need to be created by a parent or grandparent. The benefit of the third-party trust, so one of the primary advantages is that it does not have the payback provision that we talked about with the first-party trust. So you can create this trust, you can fund it, and as long as it's utilized properly, and as long as none of the funds of the beneficiary are put into that trust, then there is no payback provision. So upon the primary beneficiary passing away, the state will not claw back and collect against any of the money in that trust. So then the creator of the trust, that individual can decide what happens to the remaining balance of the trust. So you can decide who you want that to go to. So you get to pick who the beneficiaries of the trust are after the primary beneficiary has passed away. That is the prime benefit of that third-party trust. So a third-party special needs trust can be irrevocable or revocable. Then typically what you want to do with a trust like that is upon the individual's passing, the creator's passing, the trust will become irrevocable then. But you can have it be revocable during your life if you're the one creating it. The idea of the third-party supplemental needs trust or special needs trust is that the money that you're putting into that trust is meant to supplement and not supplant any kind of public benefit that individual may be receiving. So the idea of that is that public benefits will pay for what it needs to pay for, and then the trust is there to pay for the extra things that the benefits are not paying for. That's the main idea of that. So third-party supplemental needs trusts, in my opinion, are the best way to go when you are planning for a beneficiary that has special needs. There are also pooled trusts, and pooled trusts, the best way to think of it is it's like a master trust document, and different beneficiaries are pooling their money together into one trust. Some parents, some family members like this because it doesn't require them to go create their own trust document. There's already a document set up. There's already a trustee in place. So it can provide some ease of management and not require you to hire an attorney to do a trust to set everything up. So the pooled trust is another option. The trust must be established and managed by a nonprofit association. And if you go online and look, there are a lot of reputable pooled trust companies out there that this is what they do. This is their main focus as their nonprofit. A separate account must be maintained for each beneficiary in a pooled trust. So that sometimes is a concern for parents, but it's important to know that there is a separate account kept. With a pooled trust, you do still have a payback provision in that if it's a first party situation, upon that beneficiary passing away, it doesn't avoid a payback provision. So the one benefit of the plan is that there is a caveat in some states where the pooled trust company can actually keep the funds for other beneficiaries that are also disabled instead of being paid back to the state. So that is one benefit of the pooled trust. So one of the things that's important to understand about a special needs trust is what can the trust pay for? So when we're talking about distributions from a special needs trust, what are the kind of things that you can distribute money for? And that is a big element when it comes to a special needs trust, because it's not like some trusts where you can just set up an income stream or set up a certain amount of money to pay to the beneficiary each month. So I was meeting with a mom the other day who had this idea of how she wanted the trust to be run. So she did have a daughter who was on public benefit. She's on SSI and on Medicaid. And she said, what I would like is when I pass away, I want my daughter to I've figured out a budget, and this is a set amount I want her to get each month that will cover her expenses above what she gets for SSI, and above what I know what Medicaid pays for. And unfortunately, I had to break the news to her that a special needs trust can't be set up that way. So a special needs trust cannot be set up in a way where there's a cash distribution being paid to the beneficiary each month. If there is cash being paid directly to the beneficiary, that will kick them off SSI, and it will be a violation of the trust whereby Medicaid would stop paying as well. So instead, the idea of a special needs trust is that it pays for certain things. So it pays for certain goods and certain services on behalf of the beneficiary. There are ways around the cash limitation or the actual funds being paid to the beneficiary limitation, and we'll talk about that through the ABLE account. There's also ways that you can establish, working with the trustee, you can establish different credit card systems and things, and gift cards, depending on the nuances of each gift card, because it does have to be irrevocable where you can't cash it in for cash back. But there are very strict rules, all that to say, there are very strict rules when it comes to distributions from a special needs trust. And the reason for that is because we are maintaining the individual's public benefits. So we're maintaining the benefits for Medicaid and SSI. In order to do that, money can't directly be paid from the trust to the beneficiary. Otherwise, it will affect the eligibility for benefits. So the third-party trust, distributions made to supplement and not supplant public benefit. The first-party trust has this additional rule that the trust must be administered for the sole benefit of the beneficiary. That rule used to be interpreted very strictly. Lately, there has been, I think it was within this past year, the SSA released new guidance when it comes to this rule that makes it a little bit more flexible and gives some different examples for distributions. But that rule, when it came to first-party trust, used to be interpreted very strictly and was difficult for beneficiaries and trustees to administer. But the main idea, again, is that the trust is supplementing the benefits the individual is already receiving. I feel like they're maybe not. So we're going to talk about ABLE accounts. I thought I had a slide that talked about the different things that a trust can make distributions for. But what I want to do is just kind of give you some examples, and then we'll talk about ABLE accounts. So generally, when we're talking about distributions from a special needs trust, we are talking about things like education, we're talking about travel, we're talking about maybe therapies that Medicaid won't cover. We're talking about special nutritional diets that maybe Medicaid, the SSI money is not fully being able to cover. But travel, transportation, education, entertainment, all of those things generally is what a special needs trust is meant to provide for. So those extra things that benefits is not providing for. And that is really the goal of that special needs trust. Shifting gears and talking about ABLE accounts. So an ABLE account, in my opinion, does not replace the need for a special needs trust. And we'll talk about why. Instead, I use ABLE as another tool. So when we're looking at an overall plan for an individual that is on Medicaid or on SSI, we need to come up with a plan. So we need to figure out, okay, what are their monthly needs? What are their housing needs? What are their needs for food? What are their needs for transportation? And I know that shifts throughout life and it changes. And so we need to have a plan that's flexible. But we need to look at the overall plan and come up with an idea that we think will best work for that individual. So it may involve a special needs trust. It may involve a special needs trust and an ABLE account. It may involve neither, depending on the beneficiary and what benefits they're relying on. So the ABLE account, when you read about why it was originally established and created, I think the idea was to provide some more flexibility. I think the idea also was to provide an alternative to special needs trust, which again, in my opinion, I don't think it does that fully because of the limitations when it comes to how much money you can put into this. But the idea of the ABLE account is it's a savings account, basically, that you can put a certain amount of money in every year, and that money can be in the name of the beneficiary that is on SSI and on Medicaid, similar to the special needs trust. And those assets are not countable. So they're non-countable assets when we're looking at eligibility, financial eligibility for Medicaid and SSI. That is the main benefit of the ABLE account. So there are limits on how much you can contribute per year. The annual limitation is capped at $15,000 per year. And that is total for the account. So it's not that grandma can give $15,000, dad can give $15,000. It's a total contribution of $15,000 per year. So right there you can see that if you're planning on bestowing a large inheritance onto a beneficiary that's more than $15,000, then the ABLE account is not going to work. So the ABLE account works for small amounts or for setting some money aside to have the individual be able to access that money and use that and have control over those funds. But it doesn't eliminate the need to have a third-party special needs trust or if there's a large inheritance coming to the individual to have a first-party special needs trust. So there are not only annual contribution limits, but there's also caps on how much money can accumulate in that account for eligibility purposes. So the SSI rule is $100,000. You can't have more than $100,000 in the ABLE account to maintain SSI eligibility. For Medicaid eligibility, this is where you have to check your local rules and state rules as to what the cap is for how much the account can accumulate in order to maintain Medicaid benefits. It also depends on the plan. So if you are establishing a plan, for example, if you're a resident of Pennsylvania and you're using the Pennsylvania ABLE account plan through the Treasury's website, I believe the cap is, and I didn't put the money in here, the amount in here, I think it's like $539. It's a large cap for Medicaid in Pennsylvania, but each state is very different. But at that point, you've lost SSI. So again, anything over $100,000 and you lose SSI eligibility. But check your local state rules on that because again, each state has specific rules when it comes to ABLE accounts. So if you want to know where to go to see if your state has a plan, I put a website link on here, which is the ABLE National Resource Center. And that website I think is helpful when it comes to what states have plans. It also has some like overview on what an ABLE account is, what you can use the ABLE account for, how to set it up, eligibility requirements, all of that. So that's a good website to look to. If you are a Pennsylvania resident, I actually think the Pennsylvania website for ABLE accounts is really helpful and easy to navigate. So they have an eligibility quiz on there that you can go on and take to see if the beneficiary is eligible to create an ABLE account. And then they have different examples of what the account can be used for. So I actually think the Pennsylvania Treasury website is really helpful for information as well. So it is important to know that you no longer, so it used to be that your state had to have a plan in order to be able to establish an ABLE account. That changed. So if your state doesn't have a plan, you can still create an ABLE account. However, generally there are benefits to using your own state plan. So just like similar to 529 plans, you can establish a 529 plan in any state, under any state plan, but there are specific benefits to using the Pennsylvania plan when it comes to Pennsylvania income tax deductions. The same applies for ABLE accounts. So you can establish an account anywhere, but there are specific benefits to the ABLE account and if you use the Pennsylvania plan. And one of those benefits is there is a deduction for Pennsylvania state income tax. There also is this caveat that Pennsylvania did not elect, so when the legislation came out and the recommendations for each state when they're establishing their plan, the state had the option of having a payback provision for ABLE. Pennsylvania did not put that in their legislation when they adopted it. So there is no payback provision for ABLE. What that means is when we talked about the first party trusts and how the state can then attach to that trust and be paid back, ABLE does not have that directly in Pennsylvania. However, that can be deceiving because although they don't have this payback provision directly against the ABLE account, if the money in the ABLE account pays to the estate of the individual, there could be an estate recovery claim against that money. So it's a little bit deceiving, but if the planning is done properly, perhaps there would not be any kind of payback provision with an ABLE account, which would be another benefit. But again, you need to look at your state plan, and that would apply only if you're a Pennsylvania resident and using the Pennsylvania plan. So who is eligible for an ABLE account? So one of the limitations of an ABLE account is that the onset of the disability must have occurred prior to the age of 26. That doesn't necessarily mean the diagnosis, but you have to prove that the disability began prior to the age of 26. Additionally, you have to meet one of the following requirements. So either you are on SSI or SSDI, and that proves that you've met the disability for Social Security, or you self-certify the disability and you have a physician complete a form that says you are disabled. But those are the eligibility requirements for the disability for ABLE. One of the benefits of the ABLE account, and this is why I like to use it along with a special needs trust, is the disability, the distribution standard is broader than a special needs trust. So one of the primary benefits is that if a special needs trust makes a distribution for housing, there will be a limit on a reduction of the SSI benefit that you get that month, a 1/3 deduction. But with ABLE, you're able to make distributions for housing without any kind of reduction in SSI benefits. So that is one of the primary benefits of ABLE, in my opinion, when I'm coming up with a plan, is the fact that you can use the funds from this account to pay for housing. So Pennsylvania will allow you to make a distribution from a third-party trust into an ABLE account without any kind of reduction in benefits. So a lot of times one of the plans that we'll come up with is the third-party trust will allow the trustee to make a distribution to the ABLE account, and then the ABLE account can turn around and pay for housing, and then we have no reduction in SSI benefits. It's a nice little streamline. One difference is in Pennsylvania, you can't do that with first-party trusts. So Pennsylvania, when they're reviewing your first-party special needs trust, they won't allow you to put that provision in there and approve the trust. Each state is different, and I know I have heard from attorneys that practice in other states that have said that their state has taken a different position on that specific clause. So it's important, again, to check with your local state rules. But in Pennsylvania, a first-party trust cannot make a distribution to ABLE. So some other examples of things that ABLE can pay for. So just like a special needs trust, it can pay for education, transportation, employment support services, anything for health, prevention, wellness, financial management, legal fees, expenses for oversight and monitoring, and funeral or burial expenses. But again, in my opinion, I think the biggest benefit of the ABLE account is that housing provision, because the SSI amount that a beneficiary gets each month, depending on where you live, does not cover rent. So it kind of provides a way around that opens up more options for the beneficiary and doesn't keep them as limited when it comes to what kind of housing they can afford. Okay, so that is everything. I got through my slides. I was hoping that you all would have some questions or some things that you wanted to ask me.
Did I hear you early on correctly say that one that's on SSDI does not need a special needs trust?
Correct. So Social Security disability does not have an income or asset limitation. So if the beneficiary is on SSDI and Medicare and does not need Medicaid, then a special needs trust may not be needed.
Okay. I was under the impression that SSDI had both of those once we were told that we shouldn't apply for our daughter who turned 18 2 days ago. We should not apply until she turns 18 because they look at our assets for SSDI, and once she becomes 18, she should apply. And the Social Security Administration said that she had to maintain less than $2,000 in resources and.
That's SSI. So
Okay.
SSI is where you have the asset and income limitation.
Okay.
And then prior to the age of 18, they will look at the household income and household assets.
Okay.
So if your child is on SSI, then the special needs trust is needed.
Thank you.
Yep.
Regarding the ABLE account, is there something the equivalent of a trustee, or who administers that account? Who controls the decisions there?
Yeah, that's a good question. So it depends. So it depends on the level of capacity of the beneficiary. So the beneficiary can control it if the beneficiary has the capacity to do so, or a power of attorney, or a guardian, or some other legal representative for the beneficiary.
Thanks.
So a little more general question. I know you said that everyone over 18 should have a health care power of attorney. At what age do you think someone needs a will? And if you die without a will, what happens to your assets? And one more, if you die with a will, do your assets go into probate? And what is probate?
Sure. This is a big question. What is probate? So each state's different with probate. So I'll answer the probate question first. So in Pennsylvania, probate really is the idea of taking the will to the local county register of wills and having an executor appointed. Or if there is no will, it's where you prove who the heirs of the estate are. So each state is different. In the state of Pennsylvania, my opinion when it comes to do you need a will, I think that it depends. Attorney answer, it depends. So it depends on the assets of the individual. Most estate planning documents are really inexpensive. And so my opinion is if you can afford doing basic estate planning documents, a will and power of attorney documents, just do it because it will make it so much easier if they are needed. So a will would only be needed if when the individual passes away, they have assets in their name. Or sometimes if they have significant debts in their name that we need to wrap up and settle. So I do think that everyone over the age of 18, if they can afford it, should do a will. If they can't afford it, then usually there are local nonprofits or programs that will do days where they do wills for individuals that aren't able to afford it. I know Legal Aid does programs like that and other organizations. But I do think that you should have a will. If you die without a will in Pennsylvania, there's a statute that writes what happens. So one of the biggest misconceptions is people think, well, if I'm married and I die without a will, everything just goes to my spouse, so I don't need a will. In the state of Pennsylvania, that is not true. So in the state of Pennsylvania, what happens if you die without a will and you're married, your spouse gets $30,000 off the top, but the rest of the estate is split 50% to children, 50% to spouse. And that is assuming all the children are also children of the spouse. If you have a blended family, then it's just 50-50 between the children and the spouse. So it's important to have a will for that reason. You don't want the state to decide what happens to your assets. You want to decide what happens. But probate really is not this big, bad, scary thing. It really is just going to the courthouse and having your will proven, and having a certificate issued so the banks will do what you tell them to do with the money.
But a will's not just a piece of paper, right? It's something that has to be filed with the courts. I
So
mean, you can't go to Staples and get the boxed will, which I've seen. Somehow it needs to be filed somewhere, right?
Okay, so that's a loaded question. So you're asking an attorney if you can go to Staples and have a will done. So the answer is, so I'll answer this in two parts. So to be valid, a will just needs to be signed and dated in Pennsylvania. That's it, to be valid. However, those boxed wills leave a lot of holes typically. So an estate plan should be comprehensive, where you're looking at your assets, you're looking at your family dynamics, and you're coming up with a plan. You're talking about taxes, you're talking about who should receive the money outright and who's not good at managing money, and you're talking about minors and different things like that. So in my opinion, again, estate planning is really inexpensive. I think people think, oh, well, if you need to go to an attorney to have documents done, you're going to spend all this money. And that's not true for simple documents. It's going to be true where you get into more complex planning that the price tag goes up. But my opinion is that it's worth it because I've seen the messes that can be created where proper planning is not done. As far as do you need to file the will? So in the state of Pennsylvania, you only need to file a will with the courthouse when somebody dies or where somebody is adjudicated incapacitated. Otherwise, the will is kept in your own possessions until that time comes. You don't file it with the court beforehand. But each state's different because I know there are other states where you do have to. I think Maryland may be one of them. So each state's different, so check with your local state. That's just Pennsylvania.
Do you have any advice for spousal inheritance? Are there mechanisms for that or other
Yes.
routes?
So that is another, we could do a whole hour presentation on that because that can get really complicated. That's also where different states have different opinions on this. So in the state of Pennsylvania, a spouse cannot disinherit another spouse and maintain Medicaid eligibility. There is this thing called an elective share that a spouse will be forced to take if they're in Pennsylvania. And in Pennsylvania, you have to create actually a testamentary special needs trust for a spouse. You can't create a standalone trust. So there's a lot of more complicated, complex rules if we're talking about a spousal situation. And that's where it gets really state specific as well, because every state has taken a different interpretation on that when it comes to Medicaid and maintaining Medicaid eligibility. So all that to say, I can't really answer that question in this period of time, but you really should consult with somebody that can delve into your personal situation.
Is there a 5-year look-back period for the first-party special needs trust?
No, that's the benefit of it. So that's why the requirement for the age of 65 and below, so you have to be under the age of 65 to create a first-party special needs trust. That is the big benefit, and the carve-out is that you can create these trusts. The beneficiary could come into all this money and immediately take the money and put it into a first-party trust and have no interruption in their Medicaid benefit. So there is that big benefit to the first-party special needs trust, and that's in essence really why you would create it in that situation.
I actually have two. Sorry, I have 2 questions. One is, I'm on SSDI. Are you saying that no matter how much money I have in there, they'll keep paying me?
So,
I thought I could only have $2,000.
so if you're on SSI, so you have to look at your initial award letter, and it will tell you what you're on. So
I'm on SSDI.
Okay, so if you're on Social Security Disability Income, then SSDI does not have an income and asset limit. It's only SSI that does. So it all depends on what benefit you're on. Now, that being said, if you're on other ancillary benefits, so if you're on disability, but then you also receive Medicaid, then you do have an income and asset limit. So it's, even though you might be on Social Security disability, there might be other programs you're benefiting from that do have limitations.
Okay. My second question is, do you think it's important to start gifting to a third-party trust?
Can they, I'm sorry, can they do what to a third-party trust?
If you start gifting money, like putting money in?
So the issue with gifting is that where the beneficiary that is on benefits gifts, that's where we get into a situation of a look-back period and potential ineligibility. So a beneficiary can't dispose of assets other than putting them into a first-party trust or an ABLE account in order to maintain benefits. So unfortunately, I wish it was that simple where you could just gift. That would be nice and easy, but you can't, unfortunately. Okay.
Hi, my son has a ABLE account and we live in Maryland. So we opened it in Maryland. If he moves to another state, does he stay with Maryland or does it transfer over to another state that he's in? What happens with that?
Yeah, I think that would be where if you do move to a different state, I would look at the benefits of having that state's plan to see whether it's worth moving it to the new state or if you should keep it in the state that. So the answer is you can keep it in Maryland. You don't have to move it, and you would maintain eligibility. But there may be benefits to moving it depending on that state plan.
Hi, I have a question. My son is thinking of relocating. What documents and strategies, travel across the country or state to state?
So if he's thinking about relocating, and you're talking about what documents are necessary for that relocation or once he's moved?
No, like say, because he has nothing now, if he starts, the will, all the stuff,
Okay.
and then special needs trust, is he wasting his time doing certain things here and then moving to another state?
Yeah, okay, I understand. So the legal answer is if you've done documents in one state and they were legal at that time that you signed them, then the new state is supposed to honor those documents. That's the answer. That being said, I will tell you I've dealt with a lot of situations where people move from other states to Pennsylvania and we're updating the documents, not because they're required to be updated, but because what happens is, for example, financial power of attorney documents. When you go to the banks here get used to seeing a certain format. And if they're presented with a document that doesn't look the way that they think it should look, they'll give you a lot of pushback and hassle. So sometimes it's just easier to update them. So I would say if the relocation is in the immediate future, then wait and just have them done then. Or if it's in a year or in a few months, I would do basic documents now to have those set up, and then maybe consult with an attorney there about a trust when you get there.
Thank you so much,
Okay,
Rebecca. This
thank
was
you.
so helpful. So everybody's going to reconvene back in this room. So if you switch tables or you need to move, you can take a break, come back, and we'll have our final session with the FAers panel on choosing an assistive device.